And so it's my honor and privilege to introduce Professor Kerri Lynn Stone. She's a professor of law at Florida International University at the College of Law, and she teaches and publishes in the fields of employment law and employment discrimination, among other subjects. She's the past chair of the Association of American Law Schools section on women in legal education, and she's been named a top scholar by her institution. She also serves as a fellow at the U.S. Academy of Workplace Bullying, so she and I are colleagues on that, and the New York University Center for Labor and Employment Law. She, prior to teaching at FIU, she clerked for 3 federal judges, including 2 at the Third Circuit Courts of Appeals in Newark, New Jersey, and practiced law with a large firm. So she's moved in a number of different spheres that have to do with the law. And then she fortunately accepted a teaching fellowship at Temple University. And that's led to her being at her current position and fortunately here with us. Her published work focuses on examining anti-discrimination jurisprudence, including sexual harassment, stereotyping, and bullying. And I just want to say how I met Kerri was I was editor on a handbook for workplace bullying, abuse, and harassment. And we were, a colleague and I were handling the special occupations volume. And through a referral, I got to Kerri and said, Kerri, would you be willing to talk about how bullying shows up in the legal profession? She didn't hesitate. She says, oh yeah, I can talk about that. So I'm delighted that she's here with us today, and I'm looking forward to what you have to share with us today, Kerri.
Thank you so much. First, just Lorelei, thank you to you for having me here. I'm honored that someone like you would even want me here, so thank you. I'm honored to be here addressing you all today. I think this conference is very important and timely, and I'll reiterate what others have said. I really do hope these conversations continue on many levels. I've been asked to speak briefly today about the intersection and interface of some of these issues with the law in the United States, and I'm happy to do that. I'll start with a quick disclaimer. I am a full-time professor. I don't practice law, so I will not be able to give any insight into any particular situation that could be construed as legal advice. So I'm not, I can't really comment on anything specific in the question part, but I can speak generally about the law, and that's what I'm going to do in my talk, and I'm so happy to do that. I published a book last year that was about a broader topic than this, but I devoted an entire chapter to this and to bullying and to the law's interface with bullying in the United States, and how it has, in my view, engendered what I call a pane of the glass ceiling. So my book talks about, it's a non-exhaustive list of what I call unspoken beliefs, beliefs that are so taboo that nobody dares say them out loud, but they inhere in society. And chapter by chapter, I go through the beliefs, and I prove each one exists, even if it's not voiced. And then I connect the belief to some sort of institutional failure, whether it's that of the courts, whether it's that of the legislature, whether it's that of HR departments, wherever the failures are occurring that contribute to this intractable problem of the glass ceiling. And then I show the harm that ensues from that failure. And then I talk a little bit about some of what can be done to possibly redress some of it. But the first step in each case is acknowledging that the belief exists. And I've devoted an entire chapter in the book to the failure of any US state thus far to enact David Yamato, who's a mentor of mine and many people here. I just think so highly of him. I could do a whole talk on him. But his Healthy Workplace Bill and the failure of states to adopt the Healthy Workplace Bill, because right now, so-called equal opportunity bullying is lawful in the United States. And we'll talk a little bit about that in a minute. And I talk about that as a legislative failure, bolstered by the belief that bullying is something relegated to the playground. In this country, in America, if you can't handle it, go somewhere else. And it's that simple and it's that easy, and it does not confer any discriminatory impact. So really quickly, in the United States, employment is at will. You can hire and fire for any reason you want, unless it is prescribed by some source. And in our country, we have laws that prescribe discrimination because of protected class status. So that can be race, religion, color, sex, national origin, age, disability, et cetera, et cetera, et cetera. So unless you are discriminating because of or harassing because of a prescribed reason, you're fine. So the law, I always tell my students, is a floor, not a ceiling. And entities are completely able, should they desire to undertake, to build on top of that and to do more than the law requires of them. But they cannot do less than the law requires of them. So my book talked about the failure of the legislatures to whom the Healthy Workplace Bill was posed to pass it in any form. Puerto Rico has passed it somewhat recently, and that I think is good news. But a lot of my scholarship prior to writing the book had dealt with the what I call the acculturation of the acclimatization of boys and girls and the socialization of boys and girls as groups, and I'm speaking generally, but somewhat differently, such that you could argue that boys and girls are socialized to absorb abuse and criticism differently, respond to it in different ways. And so while the law makes a very clear distinction between harassment that is because of protected class status, such as sexual harassment or racial harassment, which is a cognizable cause of action, and perfectly lawful equal opportunity generic bullying, which is lawful, I would argue that if you look at the statistics and you look at who identifies as victims of bullying and who doesn't even identify as victims of bullying, but where the bullying is happening and how it's being absorbed and received, you find a lot of evidence that there are people winnowing themselves out of the workplace or even being winnowed out because they're not performing optimally, but that may be because not only of this generic bullying, but of the way they are responding to the bullying. So there is a discriminatory impact. And I've been writing and trying to build on Professor Yamada's work to no legislative avail, but I did devote a chapter of the book to talking about that belief and confronting that belief and sort of taking it on. Because I do believe that if we were to render more of this behavior unlawful, we would see more workplace equality. So I'll just speak briefly now. I don't have a ton of time and I want to finish on time. I'll speak briefly about the scope of the problem factually, and I will quote and cite my friend and mentor, Lorelei, here, because I did ask my research assistants to gather some factual information just to kind of provide a predicate to the talk. And of course, they brought me back all of her wonderful work. According to a series of studies published in 2019, in any 12-month period, on average, 25% of faculty members self-identify as being bullied, while 40 to 50% claim they've witnessed others being bullied. And I think this is an important fact to start with. This is rife in our profession, and it's something that does need addressing. The Cactus Mental Health Survey of 2020 gave us an enriched perception of what's going on, one of the biggest surveys to date that has taken on and confronted the occurrence of bullying and harassment in the academy. Although I will say, when I first asked my RA to get the research, it was the week of the Oscars, and he wrote to me and said, "I just want to check. You mean like the Academy, not like I'd like to thank the Academy?" I said, "Yes, that one." But he checked, which was very cute. Of the survey respondents in 2020, 37% reported having experienced harassment or bullying in the workplace in their careers, and 36% of the survey's respondents claimed that their institutions did not have strict guidelines to prevent bullying. And I know that's come up a bunch today. I want to talk a little bit about the scope of the bullying problem legally. And again, I'm just going to scratch the surface because I'm not practicing. I wouldn't be able to answer questions about more local laws or more specific laws to where people live that would bear upon their legal issues. But I'm just going to speak generally. Again, employment, the presumption of employment is that it's at will, meaning that most workplace bullying is lawful. Although, as I said, the law is a floor, not a ceiling, so entities can build on that and do more than the law requires of them. Alternatively, you could have a collective bargaining agreement governing the employment relationship, which could have in it some sort of civility requirements, or there could be operative employment contracts at work, which could have the same thing. But absent that, employment really is at will. Now, Title VII of the Civil Rights Act of 1964 prohibits discrimination with respect to the terms, privileges, or conditions of employment because of 5 enumerated protected classes: sex, race, color, religion, and national origin. In addition, the Americans with Disabilities Act prohibits disability discrimination. The Age Discrimination in Employment Act of 1967 prohibits age discrimination in employment. And there are others. There are other statutes, including one that designates as a protected class members of the armed services. So there's quite a lot out there if you look. And although the doctrine of harassment was developed in the context of Title VII, specifically in the context of sexual harassment, it's been extrapolated by courts. So you can have racial harassment, you can have disability harassment, you can have religious harassment. And courts have been very receptive to the expansion of that doctrine because in 1986, the Supreme Court recognized harassment as a cognizable cause of action that constituted discrimination with respect to the terms, privileges, or conditions of employment. What I'll say is then I'll break down for you what harassment looks like, because there are specific requirements for cognizable legal harassment. And this, again, this is only where it is because of protected class status. So there are usually 5 elements to a claim. The first is it has to be because of. The second is it has to be severe or pervasive, and there's a ton of jurisprudence on how this has been construed. I've written on a lot of it, but you can only imagine. And I wouldn't have time to get into all of it, although I'm happy to take certain questions about it. The third is it has to have affected the particular plaintiff at issue. This is a standing issue. You have to have sustained harm if you're going to sue. The fourth weaves an objective strand into this double helix of subjective and objective and requires that a reasonable plaintiff in the plaintiff's shoes be affected by the behavior. So it's objectively objectionable. And then finally, you have to have a basis to impute liability up the chain to the employer. So those are the requirements for actionable harassment under Title VII, and by extension, the other federal and a lot of local employment discrimination statutes. This applies only to employees. So if you're not an employee, that's another issue that's come up in many areas of employment discrimination. If you're an independent contractor in some respect, you don't enjoy that protection. So that's another limitation on the protection of the laws. I'm not an expert in education law, but I will share with you guys that Title IX requires institutions to protect all students, faculty, staff, et cetera, from sex-based discrimination. And this would subsume within it the definition, both sexual harassment and sexual violence. So that's another tool at the disposal of those who might be being harassed. And upon the administration's being made aware of an instance of discrimination or harassment, the institution is under an obligation to take immediate steps to redress the issue. And this is the main piece of civil rights legislation right now, protecting against sex discrimination at colleges and other educational institutions. You might have heard of it in the context of sports equity, but it does crop up in terms of certain types of harassment. So if you're looking, in a world where bullying is lawful, if you're looking for tools in the toolbox, this is another one to keep in mind. All right. And this law applies to all educational institutions receiving federal funding. It's a federal law. And so there has to be that hook there in order for liability to kick in. Another thing that I like to remind people when they're thinking about their legal options, and again, to the extent that you're thinking about your own case, I'm going to have to send you to an attorney because I couldn't sit and chill with everybody's, and that happens sometimes. But I will say you should not forget about sort of basic garden variety tort claims that can accompany an employment discrimination claim. So what do I mean by this? There we're talking about something like intentional infliction of emotional distress, defamation, slander. This can all accompany bullying and be part of that unfortunate bouquet or constellation of behaviors, or even assault and battery. So you might even run into criminal law territory. And I always tell my students, if you're a specialist in one area, don't be blinded to the implications and overlaps of other areas, and know when to get the person from your firm who specializes in criminal law involved if necessary, or tort law. With new platforms, social media, the expansion of the workplace, you're seeing bullying in all kinds of new contexts. The contours of the workplace are being blurred. And whereas it used to be, when I taught this stuff, more toward the beginning of my career, we would talk about flight attendants on a layover, and they're at a hotel and they have to be there, but they're not on the clock, and something goes wrong, and blah, 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 blah. And we would talk about these very extreme kind of specific situations. But since COVID and since the rise of Zoom, And since, even with the rise of social media platforms prior to that, we're really talking about situations where people work more and more, people identify more and more with work as a central core piece of their identity. They spend time talking to their quote unquote work families, maybe more than they spend talking to their own families. And these are all contributing factors to interactions that occur sort of on the periphery or the fuzzy contours of the workplace that make us question where it stops and starts at all. So if something goes on in the conversation portion of a Zoom or on somebody's Facebook page and there's bullying, how is the law to address that? And that's where I think we have to look more closely at where slander, libel, all kinds of defamation claims pop up. And these should not be forgotten by attorneys who are dealing with bullying victims in or out of the academy. So I think that's particularly important. I also personally feel like if you go after somebody, and this is more generally not specific to the academy, but if you go after them on their Facebook page, I've heard people argue that's not as bad as an at-work, in-person eruption. I think in some ways it's worse because now you're not just doing it in the break room in front of like Harry in the break room. Now you're arguably abusing and humiliating this person in front of their cousin and their kindergarten classmate, and it's far-reaching. So these tort claims that are generated, I think we need to pay very close attention to as well. Now, the flip side of this, and this is sort of an interesting aspect of what goes on, is that sometimes and I've written a whole article about this, sometimes employers who try to institute so-called civility codes or civility policies, they actually run into trouble. And let me back up a minute here. Because Title VII, which I started off talking about, is so firmly cabined to the workplace and tethered to the workplace, you'll often hear refrains from courts. They'll often repeat the same refrains. We're not here to sit as a super personnel office. We're not here to say you should have hired this person instead of this person, or you should promote this person instead of that person. We're not second guessing you. We're just trying to figure out if unlawful discrimination occurred. So there's a certain amount of arm's length distance. And the other popular refrain that's often heard is that Title VII is not a civility code. And it's really not intended to be. And I talk about this with my students. It's not there to make everybody think and act and behave kindly and open-mindedly in the way we would all want to see the world be. That's not its purpose. It is there specifically, it was enacted specifically as part of larger civil rights legislation to ensure equality of opportunity in employment. So the gist with Title VII and what is rendered unlawful under the law currently is that you can be whatever kind of person you want to be outside of work, but when you come to work, the decisions you make and the impact those decisions have should not be guided or predicated in any way by your employee's protected class status, where those classes have been designated. Again, beyond that, it's really sort of free markets, right? And a lot of people have argued, in fact, that we don't need to regulate, beyond that, or some people have even argued we don't even need to regulate that far, because a workplace that engenders or fuels or foments an abusive environment is going to suffer on so many levels that they will be incentivized naturally by the marketplace to stop it. And I see the raised eyebrows and I respect the raised eyebrows. I share the raised eyebrows. I do. I'm trying to give you guys, like I give my students, like all the different sides. And it is true, right, that there are costs. There are costs to morale. There are costs to the bottom line. There are costs to PR. There are direct costs and indirect costs to shareholders, customers, any kind of constituent of any such enterprise where there's this kind of a culture. So there are some natural incentives to do this. Personally, enough, you can read my book and I talk about that, but I try to give my students all the different arguments that are out there so they can see things from every angle. So what happens then is that, like I said, companies see the law as a floor, not a ceiling. They undertake themselves to create their own little civility codes. And they are presumptively allowed to do that. Employers enjoy managerial prerogative. As long as they're not running afoul of the law, they can create whatever type of workplace they want. Now, the tricky part, and this is what I was alluding to before, is where you have companies that have written in anti-bullying policies the law does not require them to have, beyond the anti-harassment policy that the law does require them to have for compliance. And they've written in anti-bullying policies, civility codes, all kinds of things. And what's happened in the past is that a law that everybody forgets about, the National Labor Relations Act, because of the sort of decrease in unions' influence in this sphere. We tend to forget about it, right? Because of the NLRA, Section 7 of the NLRA provides a right to all employees to join their voices together to work to change or improve workplace terms, privileges, and conditions. So what would happen, the way this would unfold, is there would be an incident, and this is I'm borrowing from different cases, but let's say there is an incident on somebody's social media page where you have a bunch of people complaining about the type of supervisor they are, the type of environment that they're creating. That person take screenshots, because that's how all the evidence is gathered now with the social media. They take screenshots, they submit them as being in violation of the anti-bullying policies of the employer. The employer maybe wants to act on that because they think they've gone too far on the person's page, and they can't because their own policies run afoul of their obligation under the NLRA to let these employees join their voices together. So that's kind of an interesting legal nook. Now, I will say this doesn't stop employers that want to have these types of policies from having them. And there are many such employers, but it's just more things to think about. I'll sum up in a few minutes, but I just, in terms of like final reflections, and I'm happy to take questions from anyone that has them. What are some best practices? I can't give you guys legal advice, but I can talk about best practices from the standpoint of someone who trains lawyers, because I train them to educate their clients, irrespective of which side of the aisle they're going to be on and who they're going to be serving as clients, as their clients. This is what, some ideas for best practices. It's if you're being bullied, it's all, and this is not legal advice, but it's always best to keep contemporaneous records, any kind of records. Now, in doing so, you should make sure that it's best to be guided by an attorney at all times, because you don't, I don't typically advise, recording things, certainly not surreptitiously. That's illegal in a lot of jurisdictions to do. It can, even if it's not illegal, it can be against the rule of a workplace, and you signed some employee manual when you started work and you agreed to, and now you're violating it, and it could be the basis for termination. So people it's a minefield, and you've got to understand all of the rules and restraints that you're operating under, those that come at you from above, like criminal law, and those that you've undertaken yourself by signing away certain rights when you step into that workplace. But you can keep notes, you can keep records, you can keep notebooks. I'm not a big fan of electronics. I still have a date book. I don't like things and I don't fully understand how, if you log into your personal email, but it's on your work computer, on your work network, I'm still not 100% sure what everybody can see. So I would just keep notebooks. Carry them with you. Don't leave them in your office. When people do get fired, oftentimes the protocol that's followed is that they're sort of escorted up to an office, and while they're in there, somebody else is cleaning out their office and locking them out from all the access they ever had electronically and physically to all their stuff and all their work stuff. So you may lose a lot of things, or you may have, have someone find some of your things or examine some of your things. So I advise keeping something with you at all times where you can record contemporaneous notes about what's going on. I definitely advise seeking help, seeking the advice of an attorney who can take you on as the client and guide you through the process. Create a record. A lot of times people say, oh, I'll remember that, I'll write that down, or I'll write it down later when I get home. They never do. And then it does become fuzzy, and there's value to contemporaneous notes. So I always advise, clients and my students who are going to be advising clients to keep them. As you're going through this, and we've heard examples today already, it's such an arduous thing to go through. It's such a traumatic thing to go through. You sometimes need an attorney to keep you sort of mindful of your own obligations, of your own, what I call your narrative arc, because if you do decide to go to court, that it may or may not, but it could easily factor into how a court or a trier or a juror perceives you. So there are cases in which somebody was right and they were being discriminated against, and then it comes out at a deposition that one day they got really angry and they took it upon themselves to take home some proprietary information because it would be a good insurance policy. Like, don't make decisions like that, because first of all, you might know it's against the rules, and you're going to hurt your case, you're going to hurt yourself, you're going to hurt your narrative, but you may be doing something that you don't even know or realize is against the rules. And when you're working with an attorney, they can guide you along the way to keep your narrative arc kind of clean. These are just some ideas, some thoughts about best practices. Looking forward at, big picture stuff, I'm really hoping to see possible policy and legislative change. The Healthy Workplace Bill is an amazing thing. I'm hoping that more states come to understand and appreciate that. If I had more time, I would talk about another piece that I wrote about the Miami Dolphins Richie Incognito saga, where for just a minute, the whole country was paying attention and talking at the water cooler about bullying, and how a guy like 6'4" Jonathan Martin, Stanford grad, multimillionaire, successful athlete, walked away from it all because of the mental health detriments of bullying. And for just a minute, people were paying attention, and all of us scholars were waiting with bated breath to see if this would carry over into a renewed interest in the plight of the night manager at Costco. And we're not sure it has. So, ever hopeful, and with a lot of good people and good tools on our side, we're kind of looking ahead to all of this. But I hope this has been helpful. And I thank you again for letting me participate.
Thanks, Kerri. There was a lot there. And so, folks, we're taking questions in the Q&A. But let me start off. There are just several things that you said that really resonated with me. So one of the things I wanted to ask about, Kerri, was the notion of a safe workplace. And what regulations are there regarding that? And what connection could that have to bullying? Because I know that NIOSH has done work over the years around issues of bullying as examples of unsafe work practices.
That's a wonderful question. So, of course, there's OSHA, which I should have mentioned as well, the Occupational Safety and Health Administration, and the act that has come from it. So reports can be made to OSHA. OSHA can do investigations and come up with conclusions that certain things need to change. Now, most of that tends to be sort of physical workplace conditions, physical dangers, a freezing cold warehouse, stuff like that. But I think that might be an untapped tool as well. So I'm glad you brought that up. Thank you.
Could you speak a little bit more about the electronic places? Because as I think about this in academia, and I do work about faculty members' experiences, I've come to the place in my own thinking, which is that faculty work is done everywhere now. And a lot has to do with electronic. We work from home. We use Twitter as a means of building scholarly community. We use a number of these things. We're all over websites, university websites, our contact information. Faculty do get trolled. They do get doxxed, all of that other type of stuff. So that when you talked about that blurry boundary for work, I think there's actually an argument to be made, particularly when it comes to academia, that in fact all of those electronic spaces in fact are our workplaces. And so if that has any legs, what does that mean for some of the laws that you've been talking about?
Absolutely. So there are privacy laws. Now, again, addresses is tricky. That's not, they're actually trying because of a tragic murder. They're working on protecting the address information of judges now, which I think is something that's because that hadn't been done, and people shut up at their houses. But typically speaking, an address is something that is readily findable, and the privacy laws tend to protect information that's not readily findable. So I think in any case where you've been the victim of anything, the first thing there are layers. So you stop and you think, well, has a crime been committed here? Have I been endangered in such a way as violates any criminal law in the books? Has a tort been committed here? Has a privacy tort been committed? Are people being incentivized or riled up to engage in an attack that might be, are there tort or criminal implications? And I think that's really important as well. And again, when you have this new media that provides this sort of printable evidence, the screenshots are really helpful. The printouts are really helpful. They always say everything on the internet's forever in some way because someone's captured it. And I think that can work to the advantage of victims in these kinds of cases, depending on what's gone on.
Is there a legal definition which it defines bullying?
So it's not against the law, right? So for harassment, yes, for harassment, absolutely. When you have protected class harassment, There's all kinds of magic language that talks about a workplace environment that becomes permeated with abuse and ridicule. And I'm using magic language from case law that is severe or pervasive, affects the victim, and would cause a reasonable person in the victim's shoes to feel affected. So we do have definitions there. Now, I will say David Yamada's Healthy Workplace Bill lays out definitions for bullying. Wait, sorry, let me just drop this.
I can get the link to that.
Okay, and the Healthy Workplace Bill does, and what I'll say, I don't have it memorized, I can't recite it off the top of my head, but Lorelai's going to drop it in there. One interesting thing that I always point out to my students when I teach them about the Healthy Workplace Bill is everyone worries about floodgate concerns, right? If we do this, then everyone's going to sue. And first of all, I mean, that's not necessary. I mean, if there's really a widespread rampant problem, that may or may not be problematic, right? If it's an infrastructure problem, maybe we need, other countries have specialized courts that deal with labor disputes. Maybe we need more, but if you are concerned about floodgates, and you need not have to be, but if you are, David Yamada's definition has a much higher standard for the harm that has to endure in order for someone to be able to sue for generic. And again, it hasn't been passed anywhere except Puerto Rico, although it's been introduced lots of places. So I do think that helps. So for example, in sexual harassment law, we just covered this case the other day in class. The Supreme Court here has held that if you're a victim of sexual harassment or other protected class harassment, you need not show concrete psychological harm. And the famous quote is, you need not show that you had a nervous breakdown that came into play before you can get relief in a court. Now with him, with David's bill, there is a more objective, lofty standard. So that does somewhat, deal with some of these concerns. It's not, I think there's a misconception out there that if we're going to make this unlawful, like we've made harassment, that any slight offense will get someone into court. And that's not what people seem to want to see. And it's not even what we have, though. When we look at harassment law, a lot of harassment cases that look pretty bad actually fail because that standard of severe or pervasive is simply not met.
And that's the one, when you were talking about the definition of the law for harassment, the severe and pervasive certainly is, and then documented harm. And so I really appreciated you saying the law is the floor, not the ceiling.
Sure.
Because one of the things I know we talk about, the crew that designed this, Morteza, Leah, Jennifer, and our colleague Sherry Moss, who was not able to join us today, is that yes, we will need laws and yes, we want regulations, but the reality is too, we want to be able to deal with this stuff earlier on so that it doesn't escalate to the level of the kind of damage that the law says it has to have in order for it to happen. Because at that point, you can do financial restitution, you can do that, but how do you repair a person?
Yeah.
How do you restore a person? How do you restore a workplace? How do you restore the people who are aware of this? How do you do that kind of restoration? So, and I wonder in academia, and it'd be interesting to have your thoughts on this, as well as any of the panelists, because they're all in academia, as well as everybody in the audience. What is it that universities can do in the early phases? So, and what, from your point of view, have you seen? And then the other part that has come into it, just got to complicate it a little bit more, is I haven't heard you talk about free speech or academic freedom and where those start to play out and potentially interact with some of the laws and regulations. Perfect.
I'll start with that. So really quickly, academic freedom is its own thing because the seminal case on free speech and employment, one of the most recent cases, I don't know if it's a seminal case, but one of them says that where you're performing, where your speech is part of your workplace performance, in other words, it falls within the scope of your job description, your employer retains the absolute right to terminate you for it. And that's very controversial, but it makes there's some surface appeal to it, right? If you're working, and this particular case arose in the context of an assistant U.S. attorney who was asked as part of his job to give an evaluation of something. And he did it honestly. He gave his evaluation and he got fired. And the Supreme Court held, that's great, do your best, be ethical, but at the end of the day, it's the U.S. attorney that you work for whose name is on the brief. You work for him right now. And if he's not happy with the judgment you're using or the way you're expressing yourself or the conclusions you're coming to, it is his sole prerogative to fire you. Now, in that opinion, interestingly, is a carve out specifically for academic freedom. And the court really doesn't say much. They just say, now this doesn't apply. There's obviously a window in here, but it doesn't really talk about. It just sort of acknowledges that there's this pocket of speech called academic freedom that that would arguably not fall within that. But it doesn't say more. And there's been a lot written in that sort of interstitial space on what goes on there. So I think that's really interesting. In terms of best practices from the employer side, and this could be a university, this could be any employer. So it's a double-edged sword. On one hand, it's absolutely best practices to clean out your house, to understand what's going on, to set standards, because again, like I said, you do suffer these costs. Every time someone leaves, there's a transactional cost, there's a revolving door, there's new training, there's disruption in morale, there's a disruption in workflow, people ask questions. So it's in employers' best interest overall to maintain workplaces where this kind of stuff is not going on. That being said, the more you set up, I always tell my students as an employer, you live and die by the rules you make for yourself. So if you have policies, formal or informal, that take care of people who, let's say, undergo an investigation and have a certain finding that might not be against the law, but is against your internal policies, to the extent you are not consistent in the implementation and execution of that policy from person to person to person, you run the risk of being accused of some type of discrimination. And in some cases, in universities and elsewhere, the biggest rainmakers, the biggest names, the biggest publishers can be the worst bullies. So when you craft these policies, whether you're putting them in a manual or you're establishing more informal policies, you're making rules either way. And if you get sued, those rules are going to be put to the test and your use of them is going to be examined. And if you are not consistent, if you're not prepared to use them every time in an even-handed way, you're best off staying away from something too rigid. So, but again, you have to ask yourself, why would we be doing that? So everyone has to be handled the same way. Now, I'd also add there's a difference between, of course, there's a distinction between private universities and public universities, because at first, and I just want to clarify, I should have said that at the beginning. I don't with my students because they know, but again, you only have Bill of Rights, First Amendment, et cetera, vis-a-vis your public employer. You don't have a first, little kids like to run around the playground yelling, I have a First Amendment right to, and vis-a-vis the government you do. But when you're at a private employer, and again, academic freedom is still a thing, but beyond the notion of academic freedom, if your employer doesn't like what you're doing, unless there's a collective bargaining agreement or a tenure contract or stuff that's usually in place around the country that says otherwise, they can do whatever they want. So up to and until, unless they violate some law. So that's sort of how at-will employment works. I hope I answered your questions.
No, that gave me a lot of food for thought. How about others, other panelists, everybody, people in the audience? You can tell Kerri's a wealth of information. Go for it.
I have one question for Dr. Stone. So one of the issues that we see, at least from the complaints that we receive, is that the perpetrator's interest is somehow intertwined with universities. So when a complaint basically comes up, the perpetrators are protected by university and they use public money to support them. But for the targets, it's totally a different story. They need to basically pay out of their pocket. And universities basically, through some of the back and forth, like court things, the targets basically ran out of money. So would you comment about that, that whether universities are, these actions are legitimate, or there's any other options that targets can basically sue the perpetrators instead?
Sure, that's a great question. So again, you have to go back to that first question, which is what happens unlawful? Right? Does something in Title IX, does something in the federal law of employment discrimination, does something in the internal policies of the university indicate that something wrong has been done? Right? Because if something is arguably legitimate and there's a discretionary call to be made, to the extent that the university or any employer makes it to side with their favorite son or daughter, there's really nothing to say about that. Now, I will say, in addition to what we've already talked about, retaliation is unlawful, but only certain types of retaliation. You have to have engaged in a protected activity. So if, for example, you filed a Title VII lawsuit and a week later you started being verbally harassed or had your evaluations, downgraded, in a way that the timeline will show was retaliatory, yes, under Title VII, if you've brought a claim, you should not be retaliated for having brought that claim.
Right.
But in general, if there are favorites and there are people on whose side they come down, and there's no legal hook to say what happened initially was either unlawful, or even if it's not unlawful, even contrary to our internal policies, there's room for them to do that. I hope that kind of.
Yeah. So one follow-up question I have is that, at least in academia, documentation is very hard. Even something, for example, for retaliation, they do, like the perpetrators usually do indirect retaliation, which is very hard to prove that. Like they use like other members of the departments to basically push the person to resign their position. So in these complicated cases, is there any like thing that the targets can do in terms of the documentation to make them, I mean, imagine that it's a law against that particular action, but the complexity of proving that that action has been happened is what I'm trying to ask here.
So I'll answer that in two parts. I'll say, from the victim's perspective, all you can do is document what's happening to you. And the more detail you give that, and the more you protect it. I like to put things in a notebook, carry it around with me. Don't leave it in a desk drawer. Certainly don't leave it on a, electronically stored with the employer. The more detailed and the more contemporaneous your documentation of what's happening to you, that's really all you can do in terms of documentation. I will share with you, there are, and this is why working with an attorney when you realize something's going wrong can be really beneficial. I'll give you examples of two different legal doctrines that speak to some of what you mentioned before. Those are just two examples, though, of things that people may not even know exist in the law before they give up. One is called the cat's paw theory. The cat's paw theory of employment discrimination says that it used to be the case where if the decision maker could testify, I fired this person, but I did not know his religion. As a matter of law, it was clear there had been no discrimination because of religion. Or I fired this person, but I didn't know she just filed an OSHA complaint. If there could be, as a matter of law, no retaliation, because you have to have knowledge to retaliate, and that makes sense. What the newer doctrine of the cat's paw theory brings into the law is this notion that if someone with the knowledge and with the desire to discriminate infiltrates your process and somehow it serves as a proxy, gets the ear of the decision maker, taints your reports or your evaluations because of your protected class status. And the case that came up and was in the context of USERRA, which is the armed services doctrine. There was someone who had a problem with someone's armed services record and was constantly in the ear of the decision maker. At a certain point, that person, it's the cat's paw, it's from Aesop's fables, but that's where they get it from. And you can actually make the claim stick even where the technical decision maker didn't even know about it. So it's what I call the injection of legal realism into legal doctrine. So that stuff is observed, and there is an opportunity for a lawyer to present that kind of information. Really quickly, the second doctrine that I'll mention is one called constructive discharge. And this is something not a lot of employees know about, but there is a doctrine in law called constructive discharge where you can actually quit and claim in most, not all, but most contexts where you would need to show an adverse employment action that what happened to you was in fact the functional equivalent of a termination. And the definition there is you have to show, and it's a high standard, but it should be, that even though you left, the behavior you experienced was so objectively intolerable that any reasonable person in your shoes would have felt compelled to resign. So these are tools, shortcuts, injections of realism into the legal analysis and adjudication of a case that can help to show a trier in court what really went on. So I would just use those as two examples that there is movement toward presenting an accurate picture to a trier. But again, something unlawful has to have occurred.
I wanted to thank you, Kerri. I think, I learned a lot of new things, and I'm hoping the audience did too. And the recording will also help with that. And thank you for posting your book. We really appreciate you being here. And we appreciate the efforts that you're making on your end to try to develop some more sense of what's lawful, what's unlawful. I
Thank you
appreciate that.
so much. I apologize that I have to duck out to pick up my kids, but I thank you so much.